A recent court ruling has changed a big assumption in telecom law. Text messages may not count as telephone calls under the TCPA's Do Not Call rules. In one federal case, the court found Section 227 CE of the TCPA, the part handling the National Do Not Call Registry and internal DNC lists, refers only to telephone calls, not text messages or SMS. Because text messaging technology didn't exist when the law passed in 1991, the court held those provisions don't automatically apply to texts. For businesses doing marketing or outreach by text, this creates a major shift. While many compliance programs treated texts just like calls under the DNC rules, this ruling says that may not always be correct. Why this matters here are the key takeaways. Sending text to numbers on the DNC registry may not violate Section 227C if they aren't calls. Compliance frameworks built around text messaging need re-examination. Just because it's a phone number doesn't make it a call under that section. But vigilance is still required. Other parts of the TCPA, like Section 227B for automated calls are texts, or state laws might apply. In short, the legal landscape around texts and the TCPA's DNC rules is shifting. This decision doesn't give carte blanche to send unlimited texts. It just means the call definition under some parts of the law may not apply. Any entity using text outreach should review its practices, consult legal counsel, and stay updated. Stay current on TCPA developments. Update your program today. Latest TCPA text message ruling explained. Opening scene. Professional tone, visuals of a phone receiving a text, court building in background. Narrator. A recent court ruling has clarified an important point. Text messages may not count as calls under the Telephone Consumer Protection Act's Do Not Call rules. The court reasoned that Section 227 CC of the TCPA, which governs the National Do Not Call Registry and internal DNC lists, was written before text messaging existed. Since the law refers only to telephone calls, texts don't automatically fall under these rules. Burr.com. For businesses, this is a game changer. Many compliance programs treated texts just like calls under the DNC rules. This ruling signals it may not be that simple. Here's what you need to know. Texts may not violate Section 227 CDNC rules the same way calls do. Compliance programs using text need review. A phone number alone isn't automatically a call. Other parts of the TCPA or state laws could still apply, so caution is essential. In short, the rules for text messages under TCPA DNC provisions are evolving. Companies using text outreach should reassess their compliance strategies and stay up to date with the latest legal guidance. Stay informed on TCPA updates. Review your texting policies today.